Hi everybody, just give me a moment while I get my slides up. Okay, first of all, I'd like to thank everybody coming today. I'm going to be covering off some legal essentials for this year's GCAP. A bit about myself before we get started. So a lot of you will probably know me. My name's Cam Rogers. I've been working in and around digital entertainment for over a decade now. In 2011, I started my own practice in Cam Rogers Legal, which specialises in digital entertainment with a particular interest in video game development. And I've helped studios all over Australia just develop and distribute their game for many years. If you want to reach out and speak to me about anything that's concerning you or your project, please feel free to do so. My details are there via the website, via phone, or of course via email. All right, so without further ado, let's start getting cracking on what we're going to be talking about today. So legal essentials and working with third parties. The way that I've crafted today's presentation is really starting from the things that you and your studio can control and moving outward towards the things that you can't control. Obviously, when you're working with third parties, there's a lot of trust involved. You need to start with what is going on inside your own studio before you can start focusing on trying to work out what the third parties are up to and how you can get them to work in alignment with what your best interests. So a brief overview. First of all, I'm going to be talking about getting your house in order. So that's going to incorporate some IP basics, including things like who actually owns the game. Then I'm going to be talking about the control of your own studio, which basically boils down to Shareholders Agreement, very briefly. Then I'm going to look at getting started with third parties. So this is the type of things you should be thinking about before you even enter into a contract. Things like, have you done your homework with the team? Are you able to speak with confidence via an NDA? Then I'm going to get into the actual contracting process itself. So we'll be looking at basic contract, the difference between some commercial points, which really falls on you as a team to work out, versus the legal points, which is what the lawyer should be looking after. We're going to look at the commercial things to think about, the legal things to be mindful of, and finally we're going to get into some of the things that they may ask for and whether or not we look at whether or not that's reasonable. Finally, we're going to get into some post-development issues. So if you think of an ongoing relationship with a third party that might last a number of years in the case of a development agreement or a publishing agreement, so you might have the development phase locked down, but what happens towards the end when you want to wind things up or when you want to release something? So we're going to looking at registering IP, ISBNs, and reporting of revenue and withholding tax. Now, the way that I have looked at this presentation is more or less as a type of case study. It's a bit of a swirling conversation. We're going to go down a few rabbit holes, but very broadly speaking, I've identified a studio working with a Chinese publisher, just so that we've got the backdrop that we need to be able to deep dive into some of these broader issues. So it is going to have quite a Chinese bent to it at times, but we'll get into that. All right, so topic one, getting your house in order. Now, this is where I wanted to start primarily because it's the area that you absolutely can control. And in particular, I want to talk about intellectual property. If you're looking to work with third parties, it's absolutely imperative that the IP and the project that you're working with is actually owned by the entity which purports to own it. So what that means is that if you have a company, it's the company that needs to own the IP. And you've got to bear in mind that copyright must be assigned in writing. So even though you've set up a company, there's a number of shareholders that are on the ASIC register and everybody is working in unison, unless there is an agreement in place, then each one of the individuals who's contributed to the game at that stage will still own that piece. So what that means is that when you set out to start your company, you need to work it out at the beginning, who owns what, how they own it, and how it's assigned over into the company. And as I say, copyright must be assigned in writing. So that doesn't necessarily mean that you have to have a super long and complex document that arranges for that. You just need to have a written instrument that allows the IP to pass from the individual directly into the company. And in that way, the company owns all the rights that it needs to. And it's not just shareholders that are impacted here. Obviously, this impacts contractors and employees as well. So anybody that's contributed to the underlying rights in the game or the project that you're working on, you need to have an agreement in place that means that the company owns and controls the rights. Now, I've seen several examples, unfortunately, where rights issues have resulted in the game not being able to be released, and TV projects for that matter. But quite as outside of that being a disaster for the team themselves, if you don't control the IP and do subsequently sign a publisher's agreement, there's going to be warranties contained in that document, which essentially you'll automatically be in breach of, which could lead to a lot of trouble down the track. So first things first, let's look at what we can control. Let's look at the IP and ensure that that is where it needs to be. That's the first and foremost thing. Moving outwards from there, the company now owns the IP, you're looking good. So you've got to ask yourself at this point, how are we actually going to run this studio? What type of rules govern who does what? How do we make decisions? What do we see as a company that is our priority? So what we're talking about here is known as a shareholders agreement. The shareholders agreement is essentially the rule book, if you like, that clarifies how you as a company make decisions. So it's the thing that everybody can rely on. Now, there's no hard and fast legal requirement to have one of these documents. And in fact, when you set up a company, you will get a constitution automatically, which does govern some similar elements to what a shareholders agreement would govern. However, it doesn't go into a lot of detail. It's the same document that's automatically generated whether or not you own a fish and chip shop versus a car mechanic versus a game development studio. Very broad, doesn't mine down into a lot of detail. When you do enter into a shareholders agreement, you can really dig into how you want the company to be run. Things like, how do we appoint directors? What happens if we want to sell shares? A lot of developers that I deal with are relatively young. A lot of them have just moved out of Swinburne or AIE or one of the other institutions we have here. And young people, you know, life is prone to change. So somebody may be working with the company initially, life changes, they want to get out. Well, how do we, what's the process that best suits our company to allow that transaction to happen? So the other thing that it does with a shareholders agreement is it gets everybody on the team on the same page. Essentially, I like to say that you ask the hard questions early when everybody is happy, because if you ask them later on, when somebody has got a grumble or a gripe of some sort, it's much harder to resolve. So right at the very beginning, think about these issues about what happens if somebody wants to leave, how do we raise capital, any of these other kind of pertinent questions that are going to impact how the company operates. Do it early, get it all sorted out, put it into a shareholders agreement, and then there it is. Now, in a perfect world, you may put that document into a drawer and never have to rely on it again because everybody gets along like a house on fire and there's never any issues. But in the real world, over the passage of time, unfortunately, these types of issues arise, and having that document in the top drawer that you can rely on is extremely useful. Now, I don't want to be the doomsayer here either. I mean, sometimes it's not just about managing disasters, it's about managing success. You know, you release your game, it becomes a tearaway success. What does growth look like? Is everybody on the same page? How are we going to build out our studio? Are we looking to IPO some point in the distant future? Or are we looking to sell the studio to somebody else? What are the priorities? And the shareholders agreement is the best place to get that done. All right, so at this point, you've got the IP in place, you've got the shareholders agreement in place, everybody's on the same page, you've got the project that's ready to go, you're looking around at publishers in China and you're thinking, okay, how do we get this done? So what I want to talk about now is basically getting started pre-contract. So this is before the document even arrives on your desk. This is about doing your homework and thinking about your game and what's best for your studio. So you attend PAX or you in Boston or somewhere else, and a team approaches you and says, we love what you're doing, we'd like to work with you. Okay, well, that's fantastic. The first thing you need to think about is, who is this team that you're thinking of working with? Do they have any track record in this type of game in this territory? There's no point working with a studio or a publisher with expertise in party games when yours is a first-person shooter or some other genre. So do your homework. Don't just say yes to the first team that comes along. Ask them some pertinent questions. And some of the types of questions you need to ask yourself are, do you actually need their help? Like, what are they actually going to contribute? So in China, it's slightly different because of localization requirements and also the need to get copyright registration and an ISBN, which I'll come to later. But often when you're working with people in North America or even, domestically, people put their hand up and say, I'll help you publish the game. And really their experience is quite limited, or they're relying quite heavily on a relationship that they may have developed elsewhere with somebody inside Steam or somewhere else. So you need to ask pertinent questions about what it is that they're going to do and what their skill set is to ensure that you've matched the best fit for your game. Once you've got past that hurdle and you're satisfied that, yes, we're prepared to talk to these people a bit more, let's talk. So how do you talk frankly about what it is that you're doing without creating any unwanted consequences? Well, the primary way of managing that issue is through what's known as a non-disclosure agreement. Now, there's a bit of confusion I often find from my clients about what this actually means in practice and what it actually allows people to do. So essentially, all it does is allows parties to discuss the business opportunity that you're talking about in some detail. That's it. You sign it at the outset. You get to talk more about the IP. You get to talk more about your team, your plans, what it is that you want for the game. They can talk about the financial side of things, how they plan to localize, how they plan to distribute, the relationships that they have, not only with the platforms in China, but also with the agencies required in order to register copyright and get the ISBN and things like that. Essentially, personal information to the company that would be that neither party necessarily wants to let out. And so the non-disclosure agreement, once signed, simply allows you to do that in isolation. Now, that's what they're notionally purported to do. What we need to look out for, though, is some sneaky little tricks that I often find. So whenever I get a non-disclosure agreement in front of me that's been issued by a third party, particularly larger third parties, is that they often try to sneak in a little IP clause somewhere towards the back. And the implication of that is essentially that in the course of the conversations that you're having, any new ideas that happen to be discussed belong to them. Now, in the context of a publisher-developer relationship, where the onus is on us as the developers to be talking about our ideas, that's obviously a massive conflict. We can't have a situation where us talking about our game idea results in the underlying IP and anything that we've discussed with them or written down is somehow assigned to them. So always make sure that you look for an IP assignment within the NDA and get it struck out. The other thing, and this is a slightly more complex kind of area of law, but often you see an entitlement to injunctive relief within these non-disclosure agreements. Now, the problem with that is that it can implicate third parties that you may work with in the future. So to illustrate, you sign the NDA, you talk to company A about what it is that you're doing. Okay, thanks very much for the conversation, but no thanks. We don't wish to work with you, and we move on. Subsequently, you go to company B, it's a good fit, you decide, yes, that's what we want to do. Now, if there is an injunctive release clauses, there is the potential in certain circumstances, if company A believes that their rights have been infringed, to allow them to stop the distribution of the game that you're working on with company B. Now, that's obviously a significant power for them to be able to do. And even though it is highly unlikely that it's probably going to happen, if I see an injunctive relief clause in an NDA, I immediately strike it out because it impacts not just your studio, but potentially a third-party publisher. And from a risk perspective, that's dangerous because then not only is the game not able to be released and you lose your money there, but you've got signed an agreement which has made certain warranties with company B with respect to the game. and they may have invested money into the game at that point in the areas of UA, marketing, so forth. They then lose their revenue and their expenditure, and their insurer will come looking at you. So the risk of an injunctive relief is quite significant, and I would always encourage you to get that struck out wherever possible. All right, so the studio is looking good. You've got the IP, you've got the shareholders agreement in place, you know how to manage it, you've done your homework on the team, you've got the NDA signed, you're ready to have you've had the conversation, you're ready to go. So that means that you're ready to step into the contracting process itself. Now, before I get into the specifics of a publisher agreement, I just want to talk about some basic contract law. So essentially at this point, it's good to keep in mind a few things. For a contract to be legally binding, it has to contain an offer and an acceptance, consideration of some sort, and an intention to create a legal relationship. So that's the sort of building blocks, the fundamentals, if you like, of what contract law actually is. So you need to ensure that all of these elements are in place. It's worth remembering that they don't all necessarily have to be contained in the one place. So if you're not careful, the contract itself can form part of what was agreed, but not all of it. So as far as is reasonably possible, we need to ensure that we put everything that pertains to this deal is contained within the document itself. And I'll get into that in a little bit more detail in a moment. But for now, in terms of basic contract law, what's important for you to understand is that for a contract to be enforceable, there has to be no doubt as to what the parties are actually agreeing to. So, say for example, one party agrees to pay another party in return for the delivery of certain game assets. So each party is promising to do something for the other. In that case, it's important to define precisely who is responsible for what and what type of consideration is being paid. So this is the basic subject matter of the contract, and out of that can arise many questions. So that's a bit of a primer on basic contract law, but from your perspective, it's always important to make sure that you're doing something, they're doing something, and those two things are directly connected. And in that way, you can ensure that there is an intention to create a legal relationship. The next thing to think about is more to do with the pragmatic side of things. So you've got a contract that's been handed to you by a publisher. Clients often come to me with a publisher agreement. They'll email it to me and they go, there you go, Cam, let us know what you think. Well, the first question I have is, what is the relationship that you want me to document here? What are the commercial points that you've actually agreed to with this publisher that I can then review and ensure the document reflects what you've spoken about? I think that there's often a bit of a misunderstanding about the role of the lawyer, at least initially. Technically speaking, the role of the lawyer is to assess the legal side of the document, and they make sure that the document confirms to your commercial understanding of the arrangement. Now, obviously, there's a bit of a business affairs crossover with the legal with respect to this, because I've obviously seen a lot more publisher agreements than perhaps you have, and I can always give my insight, but fundamentally, I'm going to be, informed by what you tell me about what you are trying to achieve. So as a pragmatic point and as a cost-saving point, I think it's worth making sure that you think about what's important to you and ensuring that you can provide the lawyer with clear, concise instructions. That way you'll save time and you'll also save some money. So as I say, what we're looking to do is define precisely what the contract is for and who is responsible for what. And that's the basic subject matter of the contract and where the questions can arise. All right, so at this point, we've looked at a bit of basic contract law. So let's start digging into the publishing contract itself and what it actually is trying to do. Fundamentally, a publishing agreement is essentially just a type of license to use your IP. You as the studio own and control the IP in the game. The publisher is acquiring a license in the rights to be able to distribute your game in a certain territory. So that's, when you think about it, quite a limited grant of rights or a license of rights over what it is that they need to do. The key thing to think about there is, if that's all they need to do, then don't give away any more rights than that. Often you see in these publishing agreements, okay, we're going to distribute the game in this territory. Well, if you need only China, why does this document say world? You know, if you only need game distribution rights, why do you need derivative works rights? Why do you need merchandise rights? What do you need spin-off rights for? So think about the nature of the license and try and, as much as possible, limit it to specifically what you want the publishing team to do. That's probably first and foremost the most important thing. Outside of that, and given that a publishing relationship is likely to last a significant period of time, a year or more at least, you've got to think about who is doing what and the different tasks necessary to actually get the game distributed. So what that actually means is, okay, we are the developer, they're the publisher. We'll handle the dev side, they handle the publishing side. But what does the publishing side actually look like? And we'll get into that in a moment. The other thing to be wary of is what I was talking about earlier, which is be mindful of making agreement outside of the contract via email or verbally. So sometimes what you see is that these publishing agreements tend to morph over a period of time, particularly when the game is at a relatively early stage and there's a lot of localization work to be done, or there's a lot of other development work to be done. The agreement will often contain a schedule at the rear which talks about the deliverables and the timings and so forth. But things slip, people, the schedule changes, and people get into the habit of just email and saying, are you okay with this? Are you okay with this? Now, the thing to remember here is even though you've got the signed agreement in place, if you start to make essentially amendments to that agreement via email and other places, then that can be a problem. So let's be mindful of not unintentionally creating variations to the publishing contract by inadvertently varying them in email outside of the contract itself. If you have any questions on that area, I'd be happy to talk about it after the presentation. Now, as I was saying earlier, the role of the lawyer versus your role is the commercial points versus the legal points. So let's have a bit of a deep dive into some of the commercial points you need to think about. We've already talked about the publishing agreement being a type of license and therefore limiting it. But what about some of the more kind of practical issues about what it is that they're going to do and why this is a useful deal for you? So let's think, what are they actually going to provide? Is this something you can do yourself? Okay, so some social marketing stuff. That's great. Are they any good at it? What have they done previously? What type of frequency do they hit? Do they have any presence in other online communities that are relevant to what you're doing? Do they have a Discord server? You know, these types of queries about what it is that they can provide versus something that you can do yourself. Now, it may not just be something that you technically can do yourself. You need to think about what's primarily important. As developers, your role is to make the best possible game you can. It's not necessarily to start an online community. So if they can assist you with that, then that's fantastic. So you look at the track record of the publisher, as we discussed earlier. Who have you actually spoken to the other developers that they've worked with and what it is that they've done? So this is kind of gets back to what I was talking about before about the pre-contracting process, but it's worth repeating here. Let's just double down and ensure that commercially speaking, we understand the commercial offering that they're going to be providing to your game. Then we start looking at what it is that they're actually asking for in return. Now, obviously, that's going to be some sort of profit share, but in the contract itself, you need to look at the definition of profit. Are they asking for gross profit, a cut of gross profit? Too often people get caught up in percentages, whether it's 65-35, 70-30, 50-50. The problem with looking at the numbers in isolation is that they're essentially underpinned by what the definition of profit actually is. So 50-50 of gross profit versus 65-35 of net profit is a big difference. So you need to think very carefully about if they are taking a percentage of net, what kind of deductions are they taking off the top before that money gets distributed effectively. Then we need to look at whether or not there's anything in there around the area of exclusivity. So in this contract, it's in relation to the development of a single game. Are they saying that you can't release another game that's substantially similar with somebody else? How far do those parameters go? Does that include subsequent games? Is it blocking you in other territories? You need to think about not just the money and the royalty, but also the other issues that can come into play that are going to prevent you from being able to effectively monetize your game in other areas. Then we look at the term. We look at how long is this arrangement going to last? If things sort of start to fall apart, how difficult is it to actually terminate this agreement? So these are the type of commercial points you want to be thinking about. And then when speaking to the lawyer, raise your concerns around them and we can dive into it together and make sure that we are looking good. And from a risk perspective, we're in as good shape as we can possibly be. Next, I want you to think about the project not just in terms of the development phase. So, okay, you've got a project in front of you, the publisher is there, you've got a schedule that you're adhering to and you're developing for it, in accordance with it. That phase of the project may work perfectly. But what about the post-development phase as you move into the distribution phase? As I was talking about before, suddenly the definition of net revenue becomes important. What happens if they're deducting every different type of cost under the sun? Do we know how much user acquisition we're doing? We want to see some transparency around the marketing expenses. One of the tricks that you often see via publishers is that they'll often sign up a bunch of projects, essentially put a fire under each of them and see which one does best initially, and then throw their resources behind that individual game. What we're trying to do is ensure that any of the revenue that is actually spent by the publisher directly relates to our game and not a range of games. So we need to be sure that the definition of net revenue is, as much as we can control, clear, concise, and only deducts appropriate expenditures. So as I was saying, watch out for inclusions of non-game revenue as well. So it's not just about excluding bogus or unrealistic expenses. It's also about them including different types of revenue in the game. So if you think about the game is really just one expression of the underlying IP which you have created. Now that underlying IP could lead to a range of projects, not just this game, but multiple games. It can lead to merchandising deals. It can lead to film deals and other forms of cross-promotion in other industries. So if the net revenue definition isn't just limited to just this game, and game, for example, includes all versions on all platforms, then suddenly this publisher that you're working with has got an entitlement potentially to revenue from a much greater pool than what you actually originally intended. So you always need to be very careful about the net revenue definition. And in fact, whenever I'm looking at a game publisher's agreement, the first thing my eye goes to is the definition of net revenue. And sometimes they can be super brief. And then sometimes when you're dealing with the likes of much larger organizations in the form of Disney or something, they can be a page long. So that's really where the rubber hits the road, because that commercial point can really make the difference between whether or not the deal is fantastic or ordinary for you. As I say, the excessive deductions, we need to have a clear understanding of how that works. And then again, with respect to the finances, we need to try and include an audit clause in the contract itself, because over the period of time, if they get to distribute the game for a period of years, we want to make sure that at the conclusion of each year, we can look at the books and really make sure the deductions they've been taking are in keeping with the net revenue definition that we've worked on. And an audit clause is the best way to enable you to do that. Finally, we need to think about the money with respect to tax withholding issues. So it's not just a question of them collecting revenue and paying it to you. If they have to take out certain deductions at source because of obligations, Chinese taxation obligations, then they need to tell us about that so that we've got a clear understanding as to why why those financial decisions were made. And furthermore, and more importantly, we need them to work with us so that we can get the applicable tax deduction in Australia. So all of these things happen towards the back end after development and the game has been released. But if during the contracting process we haven't thought about that in advance, then it can create a problem and put definite strain on the relationship. And, you know, even when the development process has been working effectively and each party has been doing what they're supposed to, they've been providing information about how to do localization and we get along well, if we haven't done enough work on ensuring that the net revenue definition is up to scratch, then the agreement can really fall apart quickly towards the back end, which is a real shame when the game is out in the wild. Other things to be mindful of in the course of the development process. The number one thing I always look for outside the net revenue definition is ensuring that there is a robust IP clause. Going all the way back to the start of the presentation, the number one thing that I said is important to your studio is copyright. So now here you are working with the third-party studio. If we don't have a robust IP clause, we can essentially undo some of the good work we did at the very beginning. So what we need to ensure is that we own what we create and anything based on what we create. So if you think about a collaborative relationship, we're providing the original game, they're providing feedback, potentially they're doing a bit of work on it as well, and all of that work builds off the shoulders of what we've done. If the agreement, the publisher's agreement, doesn't cover off each of those categories of IP, we can run into trouble and find that portions of the IP that have been created by them may not belong to us, and that can create problems down the track. Often what you'll see is a carve out with respect to what they retain versus what we own. So sometimes in these agreements, they'll create assets, for example, that aren't based on our game that can be reused in connection with other games that they're publishing. Now, we don't need to own those rights, but we just got to be really clear about what it is that those things actually are. If they're based on art assets, for example, that exist in our game, then we need to own and control those things. If they're entirely separate, created by them, then that's their business. They can hang on to those items. What we really want to try and avoid here, of course, is the shared IP scenario. So what we want to do is we want to own everything as much as possible. And if we can't do that, then the fallback position, and I don't encourage this position in the slightest, but sometimes in certain projects, depending on how they've come about, it becomes necessary. We need to make sure that we have a license in the IP of what they've created that allows us the flexibility we need to distribute our game long term. So if they do create something that they want to retain, we need to ensure that the publisher's agreement contains a license with respect to the materials that they're hanging on to us, so that we can include them in the game and we can continue to develop the game. And in that way, if you decide to have a spin-off version of the game or some other derivative work based on your game, you'll have the rights necessary in order to be able to do that. Obviously, that's not a great situation, but sometimes it's the only fallback we have. So if you are finding that you're in some sort of a shared IP situation, definitely speak to your lawyer, because that's something that needs to be navigated quite carefully. Other things to think about is user privacy. Now, we're using the example of China here, and that means that you're sort of outside the scope in the context of this agreement with respect to GDPR and other forms of legislation. But it is always important to remember that we need to understand how they're using the game users' information. It's important to remember that we're the data controller, and responsibility to the user lies with us. So essentially, we're engaging the publisher to provide certain services on our behalf. This is a general position. And so therefore, anybody that's operating and utilizing data that's captured from within our game is our responsibility. So in the publisher's agreement, we need to have a clause in there that looks at how data is being used, and we need to put them on notice that they can only use it in certain types of way that relate to the legitimate business practices of the publisher itself. Finally, let's have a look at some of the stuff they might ask for that doesn't necessarily relate to the distribution of this game, but nevertheless has an impact on your studio. One of the things they may ask for is a share of revenue on anything based on IP they create. So I sort of got into this earlier when I talked about the definition of net revenue. Sometimes it's hidden in the definition of net revenue, and other times it's not. They can be quite upfront about the fact that that's what they require. So think about that. Think about what it is that they're providing and whether or not you think that that's legitimate. So sometimes the best way to get a deal over the line is if you say, okay, we understand the amount of work that you're putting into distributing and getting the profile of this game and its underlying IP out there. Therefore, we are prepared to offer you a share of revenue, not just in this game, but potentially in other projects as well. But again, that's something you need to think through quite carefully. Another thing that you will quite often see is what's known as a first right of refusal or a first and matching right. And both of these things are essentially a type of option. So what they'll be looking to do is say, okay, in consideration for the good work that we're doing on game one, if you release a subsequent game, we should be allowed to publish that game as well. So that's your basic option. But sometimes there's a bit of detail attached to it. They'll say, okay, we only want to be able to publish that game at the right price. So what they'll say is, we will publish the subsequent game on the same terms as is contained in this document. And sometimes you leave it there. And then sometimes when it goes to the first and matching right, it essentially means that they get to pitch on the subsequent game and say that they'll do it at a certain price. We get then to subsequently shop the game around to other publishers and see if we can get a better deal. And if we can get a better deal, we've got to take that deal back to the original publisher and they get to match it. So all of this is in and around subsequent works. And sometimes it's not just this game that you're thinking of. If you're thinking of building out a franchise, these types of issues become more important. I don't necessarily have any problem with first rights or options as long as they're crafted effectively and they're easy to exercise and each party actually understands what's going on. Again, this goes back to the beginning of the presentation when I was talking about doing your homework on the team, because if we sign an agreement with these people, which contains a first right of refusal, then suddenly it's not just this game that's being impacted by that fundamental decision, is it? It's this game, it's the next game, and potentially the game after that. And you do sometimes see first rights lasting 10, 15 years. So that can be the basis for a very long-term relationship, which, you know, is generally a good thing, unless, of course, the team that you're working with has not been up to scratch. So really think through those types of issues as well. All right. Now we're kind of at the point where you've been working with the publisher for years, or a year or so. The game is there. Everybody's happy with the localization. Everybody is looking at the game and thinking, right, let's get it out there. So this is where I'm going to lean a bit more heavily on the Chinese side of things, because that's the example that we're using. So in the case of China, there's essentially 2 steps that need to be followed in order to get the game distributed over there. The first one is a legal requirement, and the second one is a cultural requirement. So the legal requirement speaks to the registering of the IP. Now that absolutely has to happen. So you can technically do that yourself as a studio, but unfortunately, just pragmatically speaking, due to the language barrier and a few other things, it generally gets done by the game publisher. And that means that it gets done under the publisher's name for practical reasons. Now, that is generally a bit of a heart in the throat moment for most devs, because it essentially says that the underlying IP in the game itself is actually registered to the publisher. But unfortunately, that's the way that it does tend to happen over there. Now, the good news is that it does tend to be quite well understood outside of the context of the document itself, that the IP does belong to the developer, and we are only talking about registering of the IP in China itself. So it only impacts that territory. What I normally try and do is have a provision in the publishing agreement that speaks to this point. I like to have an upfront conversation with the publisher upfront about how they get the IP registered, who they're working with, and develop a sense of trust with them over how that process is going to actually be undertaken. Because really, when you're working with a Chinese publisher, that's one of the most fundamental things that we're actually going to be needing from them outside of the cultural test. And then included in the publishing agreement, usually in the form of a schedule or some other addendum, there's a mechanism for ensuring that at the conclusion of the relationship, that registration can be terminated. It's difficult to get the copyright transferred once it is actually registered. So the typical way that it's done, in my experience, is to include this schedule which says that at the conclusion, it's pre-agreed that that gets automatically terminated. At that point, the copyright registration ceases. And then before you can re-release the game in China, you have to get the copyright registered again, which typically means working with another publisher or some other agency, or going alone and doing yourself. In my experience, I've never actually had a disastrous issue here, as kind of risky as that sounds, getting the IP registered under the name of a third party. It always ends up back in our hands. So that's at least something to alleviate any concerns you have. And to the furthest extent possible, I always ensure that in the contract itself, there's provisions about how we terminate and what needs to happen in order to make that happen effectively. So that's the registration of the IP. The next step is the ISBN. So the ISBN is more or less the cultural requirement. So what happens then is that the game gets sent into the Ministry for Culture. The Ministry for Culture will look at the game for the kind of localization. We'll look for the cultural elements to ensure that as a foreign game or as a domestic game, it's appropriate to be released in the territory. The things that they'll be looking for are somewhat unusual. They'll be looking to ensure that there's no sign of blood, typically speaking, in mobile games. They'll be looking to see that there's no mention of any Western characters inside the game. They'll be looking to make sure that there's no reference to Western nations inside the game, and a bunch of other things. Interestingly, I was speaking with a colleague of mine only yesterday, actually, that informed me that at the moment, obtaining the ISBN phase of the development of the distribution of the mobile title is not necessary for mobile at the moment if there is no DLC or in-game purchases. So what that means is that if your game is only doing ad revenue and doesn't contain any DLC, you can sometimes bypass the ISBN phase. Interestingly, that it's interesting to note that this year, only 55 games from the West have actually been approved by the Ministry for Culture and obtained an ISBN. So you can see that it's pretty much crucial that you're working with somebody on the inside over there to enable you to get this. But if you do want to go it alone, ensure that there's no DLC, and you should be in a pretty good position potentially to get it over the line. All right. Yes, and we've covered off the copyright registration issue. Finally, so again, we're at the point now where the game has been released, the copyright has been registered, you have the IBN, the game is out in the wild, the revenue is starting to pour in. This is where you start looking back at the contract of the definition of net revenue. You start looking at the withholding tax implications. You start looking at audit and the cost of the audit. And hopefully things are going swimmingly and they're providing you with regular revenue and they're providing you with reports, and the reports are confirming that the revenue is in line with your definition of net revenue in your contract and everything is fine. But if you do run into issues, suddenly this is where the audit clause that we spent time on during the contracting phase comes into play. We look at then getting an independent accountant to go and look at the books and also have a discussion around who's going to pay for the cost of that audit. So typically what would happen is we would enact the audit, but if there's a discrepancy of more than 5% over what is owed to you versus what they paid for you, then they would pay for the auditor. And in that way, there's a bit of fairness. Again, we need to ensure that they are actually assisting you in getting the tax credit in Australia with respect to any revenue that they've had to deduct on their side. So all that stuff should be contained in the contract, and we think about that during the contracting phase, but it's not until the very, very end that these issues suddenly become important. So as I was saying earlier, it's important during the contracting phase to think about all of the development process and into distribution. Don't just think about those matters that are important to you as at the date of signature. All right, everybody. Well, that was a fairly breezy overview, and I'm aware of that, and I've packed a lot of information in. Just wondering if anybody has any questions. I am sitting here at the moment inside Zoom, frantically typing away. So if anybody wants to reach out, please feel free to do so. And once again, thanks very much for coming to my presentation today. And if you have any questions, don't hesitate to reach me via any of the means that I mentioned at the top of the talk. I really appreciate you coming, and have a great day.